Hi everyone, good afternoon. Good
Good
afternoon,
afternoon.
everyone, and you're welcome to season 3, episode 9 of the NBA-SBL Business Law Weekly. It's good to have everyone here again. As you well know, we are looking at something very interesting today, an interesting topic um, that has to do with navigating the landscape of third-party funding in Nigeria, best practices and insights. But before I do that, I would like to acknowledge the presence of the SBL chair, that's Mrs. Ozofo Latsugemudia, the new NBA-SBL chair, and all members of the ESCO as well. Thank you very much for giving us this opportunity. Right. Without further ado, we'll delve into today's topic, which I suppose is very, very interesting. And what irony would be if you have an interesting topic or area of discussion and you do not have an eminently qualified panel to unpack the issues. And esteemed members of the audience, we have a diverse lineup of discussants, a diverse lineup of panelists today who will be doing justice to the subject matter of our business weekly series. I think I'll introduce first the only female on the panel. Her name is Opeyemi Kalejai. Opeyemi is an investment advisor. It's nice to have you. Opeyemi, you're welcome.
Good afternoon. It's an honor to be here. Thank you very much.
All right. I also have Deji Sarumi. Deji is the co-founder of Tech Hive Advisory, and they do a lot of work in the startup legal advisory space. Deji, thank you for your time. It's good to have you on the virtual event today. All right. I also have here Tomisin Kolaole. Tomisin is the CEO of Ripple, and they are a Nigerian startup with operations in Canada and the United States of America. And they've also raised funding from these jurisdictions as well. You're welcome, Tomisin.
Hi, Timmy. Hi, everyone. It's great to be here. Thank you so much for having me.
All right. And last but not the least, we have Gian Paul. Gian is the regional portfolio manager for Omni Bridgeway, and they are perhaps the largest dispute funder in the world. It's a pleasure to have you today with us, Gian. You're welcome. How's the weather in the UK today?
Cold. Very cold. But thank you for having me.
All right. Thank you. Thank you very much. I can hear you. Thank you, everyone. To the esteemed members of our audience, please sit back, relax, and listen, engage. We expect you to take important notes, and also so that you can ask questions. You could probably drop them in the Q&A box so that at the end of the session, our panelists can begin to entertain those questions. Thank you very much, everyone. I think I'll be starting from Opeyemi, the investment advisor on our panel today. I will start from her.
Yeah,
So
good
Opeyemi,
afternoon.
can you hear me?
Yes, I can. Good afternoon.
Okay. I just want to be sure you can hear us.
Yeah.
Well, before you just delve into some of the questions I'll be asking, as well as other panelists, I think I'll just give some sort of opening statement on what third-party funding is all about. A while back here in Nigeria, under the Arbitration and Mediation Act 2023, a game-changing provision was introduced in the Nigerian legal or dispute landscape. And what that means is that as of today, by virtue of that game-changing provision of the law, parties who are involved in arbitration can now approach some other entities who are not directly involved in that dispute to fund either some or all of the expenses of that particular dispute. And this is something that is very popular in other parts of the world, such as UK, and a number of other jurisdictions, Hong Kong, Singapore. The third-party industry there, is thriving really, really well, which is why we have someone from such jurisdictions present here on this panel. And that comes with a number of implications. It means that, we can now as well say we have that industry in Nigeria, and I think it's worth over $4 billion or so globally. And there has been an uptick in the amount of funds that have become available for disputes, all across the world as far as third parties concerned. The African Arbitration Association, according to them, about 31% of defendants who were not able to afford the expenses of arbitration had to resort to third-party funding. Now, this has lots of implications for businesses, right? Because businesses, as of today in Nigeria, can now take advantage of that provision and save some of the costs they would ordinarily have, expended on disputes. And what that means is that such funds could now be channeled into expansion, into revenue generation, to profit maximization, into their products, basically, right? So you now have a situation where businesses, startups, and everyone who, because of what they do in terms of their business, can be involved in some disputes or the other. They can now take that heavy expense of, I'm involved in arbitration or litigation relating to arbitration. They can now take that burden off their chests thanks to third-party funding, right? And so Opeyemi is going to get the first bites on this issue, and I'm going to ask you, from your experience, I know you have a background in investment advisory, right? And I don't want to use the word you've seen it all, right? In terms of how money moves, how funds, move around in, the different markets that we have, and now a new market is being created. So in terms of, now, from a third funder perspective, who are the investment companies that you say seem prepared to take on this challenge in terms of capital to play around with, for disputes funding or arbitration funding in Nigeria, right? Are we ready? Do we have such institutions that could perhaps expand their capabilities to start taking advantage of this provision? If you could help us identify, and what do you think should be their kind of risk appetite, knowing that this is something novel, right? It's not even up to a year. You understand? It was just in 2020, not up to 2 years, right? So from an investment advisor's perspective, we'd like to hear you. Thank you very much, Opeyemi.
Yeah, thank you so much for that question. So the interest of investment firms in this kind of funding, right, depends mostly on their niche. So there are some firms that have super niche, like some investment firms invest mostly in alternative forms of investments, like infrastructure funds, cryptocurrency, and most of these investment firms have a higher appetite for risk, because the risk involved in alternative forms of investments, most of them are kind of high. And this actually fits into the category of third-party funding if we are looking at it as an alternative form of investment, because it's different from the traditional investment that we are used to, like stocks, like bonds, like commercial paper, right? So if we're looking at it as an alternative form of investment, it has to be like firms that actually have a higher appetite for risk and also have the capital available for this kind of investments. So for an investment firm to actually invest in third-party funding, right, the investment firm has to make use of proprietary funds. Now, proprietary funds are funds that belong to the investment firm, because for an investment firm to actually use their investors' funds to invest in any type of security or commodity, that security or investment commodity has to be backed by the Securities and Exchange Commission, right? And for it not to be backed by Securities and Exchange Commission, although it is now legal, they cannot use investors' funds to invest in this, to cover this kind of investment. Rather, they can use their capital, right? Their funds to invest in it. However, that capital also has to be a patient kind of capital. So there's something we call patient capital. So that's like capital that's like funds that like you don't need to use right now. You have it, right? But you don't need it. You can keep it in a type of investment for as long as 10 years, 20 years, as long as. So we see pension funds, we see insurance companies, they have this kind of capital, but they cannot invest in this also because for pension funds, they are boxed by PENCOM on the type of investments they can make, right? So it has to be investment companies that have higher appetites for risk, right? And they also do not mind alternative forms of investment. Those are the kind of firms, right, that can invest in this, right? And then, so yes, so that's that about the kind of risk and the kind of capital to play with, right? Yeah, I hope I've been able to cover your questions.
Thank you very much, Okwe. That was very precise. And I think I'll move on to DG, who happens to have advised a number of startups in and around Nigeria and also outside the country as well. DG is also a very, very versatile corporate lawyer. And I imagine he would want to maybe perhaps take a different perspective from what Okwe just shared with us. DG, now that third-party funding is legal, at least, there's a provision backing that up in Nigeria. So are we likely to witness, tech startups, who are some of your clients, or investors, maybe venture capitalists involved in some kind of arbitration? Are we likely to see them taking advantage of the kind of opportunity that TPF now provides for Nigeria-seated arbitration, where they can now shift the costs, right, of such disputes to a third party? In this case, the funder, people who Okwe just spoke about, right? Are we likely to witness such trends in our landscape now? Thank you.
Hi, thank you very much for having me. Good afternoon, everyone. I think it's more a yes and no, right? I don't think startups are probably well informed about this particular provision right now. Yes, but I think it's something they would definitely explore. I think the TPF is a very, very good avenue for them to settle disputes without actually, incurring a lot of costs in itself, right? And also stopping their operational efficiency. But in terms of being aware about it, I doubt a lot of them are actually aware. I think it would probably fall to advisors, right, who spot those opportunities to be able to inform, educate, or make them aware of such opportunities where it arises. Typically, you find that a lot of startups, right, given their size, right, you would find that they are willing to try and settle it quickly, just settle it quickly without any issues. There are very few times startups actually want to go all the way and fight it out to the end. Usually, you probably find out when it involves IP several times, right? And even in the cases I've had where startups just say, you know what, let's just leave it alone. It's not worth it in the long run. We're trying to build something here, and this is taking too much time. So those kind of startups definitely would find it very, 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 very attractive and interesting, yes, in itself. But like I said, the knowledge isn't there, the awareness isn't there yet. So not everyone is very aware about it. And usually you would find that it's advisors that usually put those clauses of mediation or arbitration in documents. A lot of clients don't really care about that. A lot of startups clients don't really care. It's usually lawyers or advisors that usually haggle over, oh, should it be in London? Should it be in Nigeria? Should it be here? Should it be there? A lot of them don't even read those particular clauses. So I don't know, I think this places an advantage for advisors to be able to direct their clients' thinking to the right areas, to be able to take advantage of the TPF going forward. But without that knowledge or without that awareness being made more persistently, I don't think we will find a lot of startups employing this particular model unless these are actually really high growth startups with very big dispute issues.
Okay, thank you so much, DG. I think that was very informative and a lot of key takeaways from some of the very interesting points you have made. And something crucial you mentioned was the awareness gap within the startup community, and also, those lawyers who actually insert those clauses, that is the dispute resolution clauses. There's still an awareness gap, and I believe that's what the NBA-SBL is up against, which is why you find fora like this where we are aggregating as a hub of commercial lawyers in Nigeria. Is part of orientation and ensuring that the awareness gap, as much as possible, is breached. And I'm sure the SBL will do more as far as bridging that particular gap you have mentioned. Thank you very much, DG. At this point, I will probably be crossing the Atlantic Ocean to ask Gian a few questions. So Gian, thank you so much once again for joining us. You've more or less seen it all outside the country in terms of how the UK, and other jurisdictions. I know you also have a background in, other jurisdictions as far as TPF is concerned, right? So now that we're about to get off the ground with this in Nigeria, what do you think, frankly, from your standpoint as an experienced portfolio manager, right? What are the factors that can attract the big names in dispute funding to Nigeria and Africa as a whole, right? And how can business lawyers that we are as SBL, how can we unlock the potential value of third-party funding in our capacities as individuals, right, and as a group? That's the SBL. I'll repeat that again, right? So what are the factors you think are crucial in attracting third-party funding in terms of the big names in that space, attracting them to Nigeria and also to Africa? And how can lawyers, business lawyers, the SBL as a whole, and its members position themselves to unlock the value in that space? Thank you so much.
Well, thank you, Temilolu. I appreciate it very much. Look, I think that you have an opportunity in Nigeria to do this the right way from the beginning, where other countries, frankly, wasted a lot of time with the ability to get third-party funding, doing it the wrong way. So the first thing I would suggest before going into the specific factors is for Nigerian and African lawyers who are looking at this jurisdiction and this forum to use TPF, to get to know how TPF works from a funder's perspective. So that means understand how our funding works, which allows us to give individual case funding, understand what the factors are that the funders care about from the investment perspective. Spend time now coming to talk to us to understand, what do you like about a case? What do you not like about a case? I think you'll be surprised to learn that it has much more to do with numbers than it has to do with case merits, as a first point. But build that understanding, and I think you'll get an immediate advantage and save a lot of time. Once we've done that, I think it's very important to build a track record of successful outcomes for Nigeria, particularly for the arbitration forum, to show it works, right? That's very important for funders, particularly as capital gets used to your jurisdiction. It sees, okay, proof of concept, right? We have to make sure that we have effective examples. That will help us as third-party funders understand how the system works. Because let's be frank, I am at a cultural disadvantage when I come to Nigeria to fund, because I do not know the ins and outs like the locals, and that's true in any country. And so I will need to depend heavily on my partners there and on knowing the system works. I'm betting that the system works. So I would say, to do this, let's start easy, right? Let's pursue claims against multinationals who commit wrongdoing against Nigerians, where you have a very clear target. I think the startups, Deji gave really good examples with the startups, where you have a startup maybe that has, in Nigeria, who has been wrong done by a multinational abroad. You have a counterparty with money who can pay you, right, if you win, who you can pursue outside of Nigeria through this arbitration process. That's almost easier than two Nigerian companies fighting each other. And so if we can prove that the system works with this baby step, I think you will build momentum. And that is how I would advise sort of the first step. So the factors really are: learn how funding works as a business for the funder, make sure that the system works, and let's start easy with some, I guess, easier claims for the funders to digest, where they really feel like there are familiar points.
Thank you very much, Gian. I think that was short yet robust. I'm sure everyone is listening, and the stakeholders are also taking notes in terms of making the system work, right? I think I'll come back to Nigeria to take Tomisi Kolaole is the CEO of a Nigerian business that has now expanded to Canada, right? And I think he has started and exited probably about 2 or 3 startups, right? So my question to Tomisi is, can you hear me?
Yeah, I can hear you. Can hear you clearly.
Oh, great. Now, how do startups, businesses like yours, how do they prefer to settle their disputes? Are they more open to litigation, mediation, or arbitration, right? Or generally, what's like the trend in the space where you do business, and what are the options open when businesses as yours, or probably your investors, when they are involved in disputes? What are the options? And a very important aspect of this question is the cost of filing that dispute. Is it a major deciding factor in proceeding with that dispute or not, particularly for arbitration, right? So what is the trend? I mean, you are a stakeholder, right? In that you're a businessman, right? So I think we have an interference. If you can just mute whoever it is. No, it's okay. Gian, you can on. It's okay. Right. So I would like to know, your perspective.
Awesome. Awesome.
Thank you.
Yeah. Thanks so much, Tammy. It's great to be here. Amazing, comments by the other panelists. Yeah, so it's an interesting one because when you talk about disputes, arbitration, litigation, and settlements, right? Something that is really pertinent and preponderant in the current ecosystem when it comes to startups these days, right? And it's a major issue because you've had a lot of startups who have actually died or who have actually closed down because they had disputes and they didn't have any means to be able to settle. So knowing that there's already a system whereby third-party funders can help to solve that problem is actually a big win for the ecosystem. However, it's also a very delicate issue because unfortunately, not every startup can actually get access to that or can actually qualify, for such kind of opportunities. Why? Because investors, on the other hand, they won't just, even if the investors has the ability to be able to, invest for dispute resolutions and stuff like that, right? They won't just invest in any startup. So the first thing for founders is you first have to ensure that your company is an high growth company. So because I was speaking with somebody like a couple of days ago and I was talking about dispute resolution and stuff like that. And I'll also give an example. I'll just keep the name of the companies and the investors involved, right? So if you probably have issues, disputes, and sometimes can actually be with customers, sometimes can be with partners, sometimes can be with fellow startups, right? And such issues probably dissolve the company. The lead thing that you have that can guarantee that an investor will probably be able to help you solve that problem is if first and foremost you have a product that is really needed in the market. That is one. Second one is this: you have good amount of traction. So what am I saying? If you are not an high growth company, if you are not generating, let's say, $500,000 to $1 million monthly, right? And probably let's say you have a dispute that will cost you like $700,000. Yeah, that's a lot of money. But the question is, an investor coming will see that, okay, you make $1 million monthly, so it means you're generating revenue, and they see that there's high potential in what you're building. that is a major factor for them to say, okay, I might want to help to resolve this issue. Although there are other things to also check in place, right? One of the major things they also check in place when investors want to come and solve this kind of problem, because I actually have an experience of a friend, a fellow founder who had such issues and they were able to resolve. First thing they check in your company is, are the founders, do they have integrity? So they want to be sure that in this dispute we are trying to help you to resolve, was it actually caused by you? Were you guys the ones that were at fault? Because no investor will want to back any company that lacks integrity. So the first thing you have to first have in place as a founder is integrity. The second one is, do you guys actually have a product that solves a major problem that an investor is interested in first place, right? And the third one pretty much is there actually large potential for scalability? Is there a large potential for growth? Because even though the investors are coming to, help as a third party, funder for dispute resolutions, they are first investors. So, right. And they want to ensure that they're going to be backing any company. They're backing a company that will most likely succeed. So an example was, in COVID, there's this very high growth company. They were doing like roughly almost $500,000 monthly. But unfortunately, some stuff happened because of the COVID. Most people were at home. So most of their customers were having issues, right? There was kind of fraud on their platform and they lost a lot of money. And due to that, they had lots of issues whereby, customers were taking them to court to resolve issues and to charge them. Most of them were trying to even put litigation charges on them, or they eventually the whole stuff was solved via mediation approaches and all, right? But where I'm getting to is this: during that period, what majorly happened was the investors came in, right? Some investors came in and they saw that, oh, these guys, their books are really good, right? Based on integrity, you guys were not the ones actually caused this problem. They have to do an internal resolution first. And the investors actually dropped the funds to be able to solve that problem. But the interesting thing is, fast forward 4 years later, they are making 10x revenue of what they were making 4 years ago. So technically, the major reason why the investors were able to actually solve that problem for them was they saw the future. They saw that, okay, this is an high growth company. If we don't help them to resolve this issue, this company is going to die. But if we help them to resolve it, this company is going to grow. So yeah, so that's pretty much my take around it. 3 things pretty much. If you're a company that has integrity, a company solving a major problem in the market, and you have high growth potential in terms of revenue and profit, you would probably put yourself in a position whereby you have access to be able to receive such kind of support.
Okay, thank you very much, Tomisin. I'm going to come back to you, almost immediately, right, with something interesting. I'm sure you probably won't see this coming, I guess, right? You've mentioned, how to, walk the talk, really focus on, high growth and integrity as well, right? I just mentioned it at the start of this interactive session that there's a lot of money, a lot of, untapped value, right, in the third-party funding space globally, and now also that Nigeria is now part of that mix. We are the third country after Hong Kong and Singapore to, expressly provide for third-party funding, right? Now that's a big plus, and it opens up a lot of value for the economy, right? Now, considering the fact that a number of traditional funders like Opemi are not, or investment advisors, right, are not used to alternative, options, investment options such as dispute funding, right? Despite the fact that it's high growth in terms of the kind of, you could make, up to 10 times the amount you've invested as a third-party funder. If the dispute is successful, right, you get, a very fat ROI, right? But ideally, you find maybe a lot of, traditional funders and financial institutions, expressing some sort of reluctance, right, in, taking the first mover advantage. Now, let me take you to India. In India today, you have organizations or startups like Fight Rights. You have the likes of LeadPay. So these are startups who are more or less third-party funders, right? So they're able to leverage on technology, as most tech startups all over the world do, in order to provide, once they assess the metrics of the disputes, as a startup, they're able to convince investors, put money in them, and they now provide those funds to disputing parties, right? And of course, they make their checks from that, and they get their returns on investment. So the Indian example, is that something we are hoping to see in Nigeria anytime soon, imagining that the usual financial institutions are not ready to take on the risks? Is that something that you see a lot of, because I mean, Nigeria is probably the top 3 startup capitals of Africa. Is that somewhere you see as a direction for emerging or new founders? Yeah, thank you. That's for you, Tommy.
Okay, yeah, thank you so much. That's an amazing question, right? Because of course, Nigeria is really known for what's to capitalize on opportunities. Especially when we talk about Africa, we always like to have first mover advantage. It's a tricky question because before that ecosystem can be really grounded in Nigeria and Africa, I think the first thing that will have to first come into play is there really a market for it? How many high growth companies really have this amount of disputes in Africa, right? So that's how I'm thinking around it. How many high growth companies have this amount of disputes? And I think Deji said something earlier. We are in an ecosystem whereby every African founder is always careful when it comes to having to spend extra money or even sell some of their equity to solve some of these problems. They prefer to take a step back and say, oh, do you know what? Let's just leave this, let it pass by. Let us focus on building our company and enjoying our revenue. We would rather take that loss and just let it go. Right. So it's tricky. And also, to be fair, like I've actually seen traditional investors, VCs in Nigeria, actually take a step in to resolve problems like this for their founders. I think I've seen 2 cases. But of course, most of these traditional investors only do it when they see that, oh, okay, our founders are actually legitimate and we see what they are building and we believe in what they are doing, right? So I think that's mostly the prompt. But in another view, if we are now talking about VCs now setting up, franchises or setting up a different form of company or whatsoever, just to focus only on dispute resolution and funding, being a third party to resolve issues like this. I think the market is still very narrow for that to actually fly in Nigeria, Africa right now, right? And of course, looking at also, unfortunately, the cases of lack of integrity and the cases of polarized transparency that we currently have in the startup ecosystem in Africa, it's probably going to be it's going to take a while for that to actually be a thing. That's where I'm seeing it, right? But I think what I probably want to encourage more is a place whereby we have legal advisors, advise, encourage, and also try to educate traditional investors, right, to take such costs for their current founders or for companies that they might want to invest in. I think that one might actually fly better. But when you make them understand and see the value, right? Let me just give an example of such values. Most times when it comes to cases like this, if an investor wants to invest in a way whereby they want to actually help to solve disputes like this, one thing they ask for is discount. They'll tell you, shut up. We know your valuation is $50 million, but we are trying to help you solve these disputes. So based on this, give us a 10% valuation discount, or give us a 50% valuation discount because we're actually helping you solve a major problem. So that's what legal advisors can do. Advise, companies, VCs and PE firms to be able to understand that, oh, this is actually a way for you to be able to get more from these companies. Not you taking advantage of them, definitely, but because you're actually helping them to solve a problem, most other investors will shy away from. Then you can use that to actually even get more in terms of value for yourself in equity, right? When you are trying to solve such problems. But setting up, new franchises or new investment firms to focus only on this, for me, I think the African market is not yet ready for it.
Thank you very much, Tomisi, for your interesting take. Just to directly attack that, I want to move on to Opeyemi now, who is in the investment space, right? Opeyemi, you've heard it from different sides, from the sides of, the business people, from the side of, third-party funders outside Nigeria, right? I mean, from your experience, there's a walk, to do, and we're already talking, right? So we need to walk the talk. What do we need to put in place as a country, right? If there's a lot of value, I mean, if Nigeria fails to take some of these opportunities, there are, other countries in Africa that willingly grab them, right? Because, I mean, you wake up tomorrow, they have enacted similar laws as well, and we have, a lot of opportunity that we can take advantage of in this regard, right? So from your experience, how do we make arbitration funding, how do we make dispute funding attractive, I mean, as any other kind of investment option? Because mind you, one of the things that, I mean, we should also know, or might also know about third-party funding when it comes to disputes is that, I mean, the price or the amount or the investment itself is not leveraged against commodities like gold, like crude oil and the likes. So it's more or less predictable as long as you are sure of, you've done analysis, right? You've done your case analysis, you've done your risk assessment, and you more or less have a predictable pattern, right? To say this is what I'm hedging my investment against. This is likely to be the award, right? This is likely going to be the money that will come in after, the award has been handed down, right? So, I mean, those are some of the things that I want us to be aware of. Moving beyond that now, how do we ensure we make it attractive, right? Because in Nigeria today, we have, lots of, monies, HNIs, money sitting in the hands of, pension funds, and they are more or less not, making profit out of it. And a lot of capital is just sitting down and is not put to good use, right? Now that we have a new opportunity to diversify our investment space with arbitration funding, or what do we need to put in place to make it attractive, right? For the pension funds, for HNIs, and for everyone who has the capacity to, release funds into the new spaces, such that in the next couple of years, you as an investment advisor, when you're advising maybe some of your clients who are intending to invest in one scheme or the other, you could as well have an option that includes, or options that includes dispute funding in Nigerian seated arbitration as one of the asset classes into it. So how can we get there? I'm really curious, and I'm sure members of the audience are also listening, and want to take advantage of that. So how do we get from, zero interest, we are just, starting the journey. How do we get there where we can now compete, where dispute funding can now compete with other forms of investment, both from the standpoint of ROI and some other metrics? Thank you very much. If you can do that in 3 minutes, I'll be very grateful. Thank you, Kwame.
All right. Thank you for that very interesting question, right? So there's no dispute that the ROI for this kind of investment would be like a lot, right? That's because the risk involved is very high, right? And you have to look at different kind of the capital you need, the cost, the time value of money, all those things. You consider everything before you determine, okay, this is the amount I want to collect, this is the returns I should get, right? However, Nigeria is a peculiar market, right? Because I believe that for cases in Nigeria, sometimes it can drag for so long, right? So there will be need to for structure to be in place in our judiciary system. Because if an investor wants to invest their funds, right, they have to know, okay, how long will this case span for? If I'm going to put my client's funds into this investment, how long will this span for? I believe in other economies, they don't drag as much as it is in Nigeria. That is why it can be a slightly difficult, right, to adapt the same thing in this country. So there needs to be structure really in the judicial system. The litigation cases sometimes can span for too long. And because most securities are backed by all investments, right, in Nigeria are backed by Securities and Exchange Commission, like I said earlier on. So investment firms cannot just invest in any type of investment. It has to be within the band that's been given by Securities Exchange. That leads me to the next point, that there needs to be, lawyers need to have like a dialogue, right, with the SEC, right? When there's a dialogue, you inform them about it, you let them know about the advantages, everything about it. SEC can then create awareness, can then put it as an option for investment firms to take to invest in. Because without SEC actually saying, okay, yes, we are taking mitigation funds as one of on the alternative investments, investment firms cannot use investors' funds for that, right? They can only use their own capital, their own funds to invest in this kind of investment. So yes, there needs to be awareness, dialogue with regulatory bodies, dialogue with association of boards of associations like FMAN, that's the Fund Management Association of Nigeria. When there's dialogue with these associations, they can create awareness, let investors know about it, and then investors can then invest either their funds or investors' funds into it if the SEC permits it. Yeah. I can't hear you. I don't know if you're muted.
Oh, thank you so much. We are pressed for time, but it's also interesting to note that the law has also moved forward in Nigeria to cater to some of the concerns you raised, new provisions that border on appointment of emergency arbitrators and also enforcement, right, by the courts, right? With the new act, you no longer find a situation where, you know, a party uses stay of proceedings, for example, to avoid or to escape, you know, arbitration obligations, right? All of that has been catered to under the new legislation. So, I mean, that brings some sort of predictability, right? Which is what investors, I believe, which is what funders or prospective funders in Nigeria would be willing to learn. Thank you very much. I think I now want to hear from Gian before I come back to Deji, right? Gian, once again, you've been very active in the global dispute, you know, funding space, and I'm sure a number of, you know, the members of the audience are interested in hearing some of these experiences, right? So, from your experience, what should we start in terms of practical solutions, right? In terms of getting off the ground, where do we start from? Opeyemi just mentioned, you know, some sort of collaboration, right, between regulators of the financial and the security space in Nigeria and lawyers. So we need to, you know, synergize efforts at the point, because I know some of the issues that, you know, be involved will be the issue of regulation, for example. How do we regulate third-party funders, right? I mean, how do we ensure there's some sort of decorum in the space? You know, what are some of the ethical issues involved, you know, right? You know, which are, you know, very, very important issues, because at the end of the day, we are still dealing with justice, right? So the ethical, you know, obligations will forever remain there. So maybe regulation, for example, where do we start off from? A number of countries have made lots and lots of mistakes. I know in the UK, there's more or less some self-regulation. You have the Association of, I think, litigation funders, right? So they employ some sort of self-regulation. So how do we, in terms of course, I believe regulation will always play catch-up to innovation. Third-party funding is an innovative step, if you ask me. So where do we draw the line? Where do we draw the balance? And what practical measures, I mean, let's, you know, assume you are consulting now for, you know, Nigeria. What practical steps do we take from where we are now to where we want to be and begin to compete with countries like the UK? Thank you very much, Gail.
Sure. Well, I think the first thing I would say is let funding come to Nigeria first and see what happens. Because I think if we start to think about regulation before we have a developed market, we don't know what to regulate. But the lessons that I would say is bring somebody like Omni Bridgeway to Nigeria and say, help us think about funding here, so that the local funders also can build their own investment businesses here in Nigeria, using the lessons that Omni has. You know, yes, Omni is the biggest funder in the world, but it is not going to be the biggest in Nigeria. And there are going to be Nigerians who understand Nigeria better and will do great business there. I think the most important thing is that from a regulatory perspective is pricing, not to regulate pricing. And the reason I say that is that what's happened in other countries is that the regulators and the public miss the forest for the trees. They look at the individual case and they say, my goodness, this is very expensive. How could it be so expensive? But they forget that this single case is part of a portfolio of 100 cases, and that the people who are investing in this litigation funding fund, the pension funds, the endowments, the universities that are giving Omni money, are investing for a blended return. And so that blended return is a combination of the wins that compensate for the losses. And so these individual cases have to be priced this way. And regulators have not understood that. And so they think only about the single case. And if you do that, if you regulate the pricing of a single case, you will destroy the market, because a single case market only does not exist. It has to be part of a bigger portfolio in order to be economically viable. And so the big impact of PACCAR, which the PACCAR judgment in the UK, for those who don't know, was a judgment that effectively made it impossible for funders in the UK to take a percentage of the damages rather than a multiple of their costs in terms of the fee. This wasn't actually regulation, it's just the effect of a decision in a related case. But capital has actually left the UK as a result of funders not being able to price their funding as a percentage of the damages. It is the most important thing because it's the most aligned with claimants. You all share the same amount on the upside and the downside if you have a percentage of pricing. And this, I think, is the most fundamental to the ecosystem that Nigeria can take the first step in realizing before regulating. And so I would just simply say, first, to summarize, let the ecosystem grow, let funding grow Nigeria into something substantial, take lessons from the outside, pick the best things, learn from the mistakes that have happened in the UK, for example, and go from there. I think you can also look at the EU and say, well, why hasn't funding flourished in the EU, right? One of the reasons is that every single member state has their own view, and then it's a big confusing place to do business. I think Nigeria can take from this and say, well, let's see if we can get all of our states in Nigeria to be harmonious, right? Of course, there's Sharia law, common law, these different things, but how can we be harmonious in that way? So, but I do see a big opportunity in Nigeria. It's a very big economy with lots of growth. It's the startup capital of Africa, and I think that's a big driver for third-party funding to be helpful. So, thank you, Tammy.
Thank you very much, Gian. I think that was a very positive one and also very practical as well. And you've given us a lot of insights and takeaways from your response. Just to also mention to our audience that there's a Q&A box for your questions, which I hope we'll be able to entertain because we are far pressed for time. Right. I just have one more question. I think I will ask Deji. Right. I mean, you're a corporate lawyer, right? In terms of your experiences in advising on finance, technology, and the likes. I know you made mention of some of these dispute resolution clauses too that lawyers can begin to insert in these agreements, particularly to ensure that the disputes, the arbitration, is seated in Nigeria. There's a lot of work to be done in that regard because there are factors that make people choose, other seats apart from Nigeria, right? So Nigerian lawyers, how they call, they are listening, right? And with all that has been said, how do you think we can better position ourselves to unlock the value in this space from a legal perspective? Thank you. And after that, we'll just take the questions. Yeah.
Yeah, thanks for that. Right. I think Gian already touched on this, right? And if I wasn't thinking about it before, right, I think it's more pertinent now. Before we can take advantage of it, you need to understand how the funders think, right? Because like you said, bring someone like his company to Nigeria requires understanding the opportunities itself. If we don't understand the opportunities, and I'm not referring to the lawyers, you will need to understand the law as well, understand the law, the provisions, and all. But you see, it's the opportunities for the funders itself, right? That would really stand out. And as business lawyers, I think what we're looking for is business opportunities for our clients. So one way for us to get ahead would be to understand the law, fine, but more importantly, to unlock value in this space, we need to understand how to create the opportunities for the funders who create the opportunities for us to actually have work in this particular area as well. right? If you understand how they think, look at jurisdictional examples, right? In Singapore, in Hong Kong, in India, in the UK, in Ireland. You look at those examples and be able and craft ways wherein you can show these funders, right, that there are opportunities for the growth in this particular sector in the country, right? That would be one way for us to look at it, right? As well as, of course, understanding the law and becoming familiar and updated with how the interpretations of the provisions will go on a case-by-case basis. I think those two things are the most important things that lawyers need to focus on. But more important, like Ian mentioned earlier, understanding how the funders think and being able to spot opportunities to help them come into the country and invest in that manner in this particular sector of the economy. Thank you.
All right. Thank you very much. I think that was very instructive. We need to understand, the thinking. We need to understand how, the funders, that is the third-party funders, how they think before we even talk about the law. So that's very important. I imagine that there'll be need for, more conversations, right? The conversation doesn't end here, right? Even though we have to close the session very, very soon. We have to keep talking, we have to keep creating awareness and also networking with the likes of OmniBridge and other third-party funders from across the world. And for those who have sent in questions, I think I can view a couple of questions here from my end. Someone is asking, what are the experiences from the Indian firms that fund dispute resolution? We need clarity before adopting, not just because they exist. Yeah, I think Gian has more or less shared some of his experiences. So I think I'll just substitute that for India, right? I think I will just substitute that instead. Or maybe I'll just modify the question a bit by, sorry, Gian, I have to come back to you again, since it's more or less like your question, right? So from your experiences as a portfolio manager, what are some of the factors that make you walk away from deals that make you as a funder, walk away from maybe a funding opportunity, for example? Everything seems, viable. There is a wealthy defendant who can pay, maybe a multinational, right? But from your experience, once you see that those factors do not align in terms of your own checklist as a funder, you simply walk away, right? So I think it's also another way for some of us to also understand the way, your mind works, right? And your experiences on the field. So like, what are those factors that once you see them, no matter how juicy the ROI is and some of the other perks of the deal, you just walk away and you prefer to leave, such deals? We'll be interested in hearing that. Thank you.
Sure. Look, I think I'll try to make it very basic because we want to make it basic so that we can give you fast answers. So first, if we receive a case from a reputable lawyer, we will assume very, very in the beginning that the merits are strong, right? We'll focus not on the merits, we're going to focus on the numbers. So you said yourself, strong multinational. It doesn't have to be a multinational, but a defendant where we can readily see they have the ability to pay. Point one. Two, what is the relationship between the quantum of damages and the budget, right? We generally look for a quantum of damages that is 10 times the cost of the proceeding. Why? And this comes to the ultimate decider, really, for us. You could have great ROI, but if in the end I am taking, as a funder, in a successful outcome, 80% of the proceeds, that is not good. We, as a funder, need to be in balance with the claimant. Our fees need to be reasonable as a percentage of what the claimant will recover if they win. And so even if we have the greatest ROI possible, if that ROI happens because we take too much, we don't do the deal. So I think that's you're just looking at me? Sorry. So that is probably the one thing, that if the quantum is big, the recovery is likely, the ROI looks fantastic, the IRR and the money multiple is fantastic. If because the costs are so high or the duration expectation is so long that we end up taking a huge fee that is a very big percentage, like 60, 70, 80%, we don't want to do it. So we try to find that balance. I would say for lawyers looking at their cases to evaluate, hey, will this be a good case to fund? I would simply say, very simple, is it a solvent defendant? How long do we think it will take? Will it take a reasonable number of time, not 10 years, but maybe 5, 6 at the most? And then a relationship of 10 to 1 between the budget and the quantum. That's a good basis on which to have a conversation. Of course, there's lots of details in the quality of the quantum. Is it lost profits? Is it actual cash that's disappeared, et cetera, right? We evaluate that, but that's sort of the beginning point. But really, I think the key takeaway is, if you feel as a claimant that you will be in a position where you don't recover much, and it's really only the funder that's getting a lot of the money, it's probably a good sign that this won't work. And because you don't want to be in that position at the end of the day. I hope that's helpful, Timmy.
Very, very helpful. Very, very helpful. I'm sure members of the audience, they are satisfied, right? And they've been able to more or less share in your experiences, right? In terms of, I can imagine, a number of business lawyers are, taking notes, and they are more or less, considering some of these factors you've mentioned, like, having a solvent defendant, and also the relationship between the quantum of damages and the budget as well, right? So that's very important, because at the end of the day, it has to be worthwhile, both in terms of what you have as a claim and, what will be the eventual, damages as well. Thank you so much. Thank you, Gian. I must also thank Opeyemi, who has been very, very brilliant and engaging. Thank you, Tomisin, for bringing the startup tech perspective to the very insightful and practical conversations we have had today. And I must also not fail to thank Deji Sarumi, co-founder of Tech Hive Advisory, who has been able to merge his experiences as a corporate lawyer and also an advisor to startups in Nigeria and from various parts of the world. We must also thank the SBL chair, who has also given us this kind of opportunity. And like we have said today, the conversation continues, right? And we must do all we can to broaden our expertise, because for Nigerian lawyers, right, third-party funding, comes with a lot of opportunities, drafting funding agreements, advising third-party funders who are probably engaged in funding some disputes in your locality, right? So the opportunities are enormous, right? But before we get there, partnerships are important, conversations are important, and collaborations are also very important. Thank you once again for joining, esteemed members of our audience. Thank you, SBL Chair, Mrs. Ozofu, Ogemudia, and also other members of the EXCO. And once again, thank you, panelists. I think the conversation will continue. Of course, the link will be uploaded on YouTube, I guess on the SBL YouTube platform, so you can join and keep getting all the insights you would get from us. Thank you very much. Till another time. Bye-bye.
Thank you. Have a good one.
Bye, everyone.
Thank you, everyone.
Thank you. Bye.